Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Friends, welcome back. Today we're once again in Calloway County with workers' compensation attorney Jeff Roberts. Jeff, how are you?
I'm doing good, Jim. How are you?
Buddy, I'm doing well. Let's jump into workers' compensation claims today. And this episode is going to focus on the various aspects because there's a lot that's covered under workers' comp that the average person out there may not be aware of. They may not realize, wow, I've got access to those kind of benefits. Yeah, you absolutely do. And Jeff, you've got 33 years or more of experience dealing with Kentucky workers' compensation claims.
That's true. I've been doing it I'm working on my 34th year now of handling workers' compensation claims in Kentucky. And, our last podcast episode, we talked about the different types of motor vehicle insurance there. And I thought that it'd be a good idea just as a general overview for people who are looking into this and don't know what the law is and need to know what the law is because they've suffered a work-related injury or some sort of work event, so that they can have some idea of what's covered, what's not covered, and what type of items they can recover if they are injured on the job. So to kind of get into that, just as a brief overview of that, in Kentucky you have you can recover workers' comp benefits if you have a work-related injury, if you have a work-related cumulative trauma injury, if you have a work-related hearing loss, or if you develop an occupational, a disease as a result of your occupation or your work activity. So those are the different types of claims that you can pursue in Kentucky. And pretty much covers anything, any kind of a injury or bodily harm as a result of a work injury or as a result of work is covered under workers' comp.
And work-related, it doesn't mean you actually have to be working in Kentucky. You can actually have a connection to a Kentucky-based employer, and maybe you're working in Tennessee, or maybe you're working in Missouri or Illinois or somewhere. You still have the option of filing a Kentucky claim, right?
Correct. There's various situations where Kentucky would provide what's called extraterritorial jurisdiction for Kentucky for injuries that are incurred in another state. There's 4 different factors that come into play in that regard that you can look at in that to make that determination. Where you live is not one of those factors. A lot of people think, well, I work in Tennessee, but I live in Kentucky, and I got hurt in Tennessee. That doesn't give you Kentucky jurisdiction. It's looking more at the employment contract and where the employment is principally localized. So if you spend 80% of your time in Kentucky and 20% in Tennessee, then Kentucky's going to cover a Tennessee injury in that situation. If you're a truck driver and you're dispatched out of Kentucky, and you go through 20 different states, so it's not principally localized anywhere, Kentucky's going to provide jurisdiction in that situation. So
okay, outstanding. Well, so let's jump into it. One of the types of injuries we've talked about before, and we've actually done a full episode on this, is cumulative trauma, repetitive motion type injuries.
Correct. Yeah, repetitive motion or cumulative trauma. And that's the type, a lot of people, when you think of a work-related injury, you think of the person lifts a heavy box, has a sudden onset of pain after they lift that heavy box, and they had no problems before. They go to the doctor, they got a herniated disc. That's covered under workers' compensation. Or if they have something land on their foot and smash and break bones, that's a work-related injury that's covered. That's one specific injury caused or incident caused the injury. And that's what a lot of people think of is all that's covered under workers' comp. But Kentucky does cover cumulative trauma. And what that is it's not one specific injury, but it's activities over a long period of time that cause that. So if you've got somebody who does a lot of lifting of weights over the shoulder, and they do that 100 times every work shift, 10, 15 pounds, and then over time their shoulder wears out, that's a cumulative trauma injury. Someone who does a lot of typing all day long and develops carpal tunnel, cumulative trauma injury is a general rule. So you've got those type of things, and what some people don't realize is that it can be an injury that they may not realize it, and I think we talked about this in that episode talking about cumulative trauma, but they go to the doctor and the doctor says, you've got a lot of arthritis. And just because you've got a lot of arthritis does not mean it's not a work-related injury if the work activities are what cause the arthritis to be at the level that it is. So if you've got someone who uses their right arm doing a whole lot of things, and then they've got a lot of arthritis in that right shoulder, and then the left arm that doesn't do the work activities does not have any arthritis, that's a good indication that the work is what's causing that arthritis for that individual. It could be the knee. I mean, you can have, if you're walking on concrete a whole lot, you have develop arthritis quicker than someone who does not do that, who's doing a more sedentary job. So you've got to investigate it a little further and have a medical professional make the determination: is this person's condition worse because of their job activities? And if it is, then it very well may be a cumulative trauma claim.
Well, and you've said in the past, a lot of times a physician might say, it's just part of the aging process. You're getting older. They're looking at the pain. They're looking at the issue that's right in front of them. They're not connecting it to the type of work you do. So it might be a good idea to bring that up in your exam, right?
Correct, and they're looking at they're looking a lot of times just at the diagnosis versus the causation. If you do an MRI of the back of a 60-year-old, they're nearly all of them are going to have some sort of degenerative disc disease going on in their spine if you do an MRI of the spine. But someone who is a truck driver who's bouncing on the road a lot now with air ride seats, it might not be as bad as it once was. But if you got someone who's a truck driver who's bouncing a whole lot, their degenerative disc disease in their low back is probably going to be substantially worse than someone who's an attorney like me who's not experiencing that same sort of trauma. Or if you got someone who does a lot of bending over and lifting, then they're going to have much greater degenerative disc disease than someone who is not doing that type of activity. So you have to go into it further. Degenerative disc disease, everybody, it's a natural aging process. Everybody develops it to some extent. But the question is, did your job cause you to have it worse than what it would be without that job? And if so, then it very well could be a cumulative trauma injury in that regard. And even the other side to that we need to mention is under Kentucky law, even if the degenerative condition is not the result of work activities, but it becoming painful is the result of work activities, it's compensable. So if you've got degenerative disc disease in your low back and your work didn't cause it, but then you did something at work that made it painful, it's not painful whatsoever, and then you lifted maybe a 20-pound box, nothing real heavy, but you lifted and twisted to put it on the conveyor belt, and have a sudden onset, and I shouldn't snap my fingers, apologize for that, have a sudden, people are going to wonder what that noise popping is, a sudden onset of pain as a result of that activity. Even though you have a degenerative condition, what made it painful is the work activity, and it's covered under workers' comp.
So basically, we're really talking about pre-existing conditions, right?
That's what pre-existing dormant, not non-painful, not seeking medical treatment, is still covered under workers' compensation in that regard. Now, if it's something you've been receiving treatment over the last 2 years, and you do that and have pain, probably not going to be covered because it's an active condition at that point in time.
But friends, as we typically do during an episode, I'm going to link to a specific episode on pre-existing conditions, and Jeff really goes into detail there about how, again, those do sometimes qualify for workers' compensation benefits here in Kentucky. So fantastic. Hearing loss would be the next one. This is another area of workers' compensation benefits.
Yes, and hearing loss in Kentucky is treated slightly different than other types of occupational injuries. Frequently when we work in, if you work in a very loud environment, I worked at, when I was going to Murray State University, I worked at the Briggs and Stratton plant here, and it was very loud. I operated a punch press for about half the time, and I worked in the die-cast department for the other half the time, both very loud departments that I worked in. From that standpoint, I did use my hearing protection, but they were very loud things. And if you work in those, hopefully you are using your hearing protection, but even if you are or not, it can result in you having some hearing loss. Now, Kentucky, when I say that it treats hearing loss a little differently, benefits for permanent disability in Kentucky are based on an impairment rating, which we'll talk about later. And if you have a 1% rating, you get benefits. For hearing loss, your rating has to be 8% or higher for you to get that to receive a hearing loss. Have a hearing loss claim or be entitled to permanent disability for hearing loss. You could still get medical treatment for it, though. And I've had this in a situation where a client was actually in a car wreck and suffered trauma to the head and lost hearing in one ear completely. There was no hearing at all. They were completely
just deaf in that
deaf
ear.
in that ear. And but no hearing in one ear and good hearing in the other ear does not rise to an 8% impairment rating, so they weren't able to get permanent benefits for it, but they were able to get the cochlear implant put in so that they could hear out of that ear again in that regard. And frankly, that was probably, frankly, it was more valuable to the client to be able to get that hearing back in that ear than whatever workers' comp benefits we probably would have. They had other injuries we were able to recover for, but whatever we were able to recover for hearing loss would not have compensated them for the loss of hearing, so getting that hearing back was more important to them anyway.
It comes back to a quality of life issue at the end of the day, right? Yeah.
Absolutely.
All righty. Well, let's transition into occupational diseases, and this is fairly broad, I think, isn't it?
It is extremely broad. Occupational diseases are, you have a lot of those. Frequently, when it's discussed, people talk about coworkers' pneumoconiosis or black lung, which is a very bad respiratory issue that develops from working in coal mines and breathing in that coal dust over the years. And that's what a lot of people think of, and probably the majority of occupational disease cases in Kentucky are those type of claims. But there's a variety of other occupational disease cases. I've represented clients in the past who worked in chemical manufacturing plants that develop respiratory issues and frankly sometimes cancer that can be covered under a work-related occupational disease if the work activities chemicals they're exposed to is what caused them to have that cancer. In that regard, heavy metal poisoning, things of that nature, sometimes carbon monoxide poisoning, all come into play can come into play and be an occupational disease there. And what a lot of people think of now, too, when they think of it, is it may be the most, at least contracted occupational disease in the last few years is COVID. COVID is a strange animal in workers' comp because it's a communicable disease. And so the courts really are not sure exactly how it's going to be handled completely yet. It can be an occupational disease or it can be an occupational injury, which is odd. And I'm not sure I quite understand why it's treated that way, but it is. The law is clear under the statute that a communicable disease can be a work-related injury. And there's some case law on other communicable diseases before COVID developed that talked about that to some extent. And because normally when you see occupational disease, you're looking at it from the standpoint like the coal industry, people have black lung, that is a known consequence of that industry. If you work in a chemical plant and around certain chemicals, a known consequence is developing these type of cases. USEC dealt with beryllium at one time anyway, and beryllium disease was a consequence of working in that situation.
It's also, I would think, asbestos or mesothelioma falls under this, right?
Right, if you work at a plant that's got asbestos and all of that. So if you develop, if you develop coworkers pneumoconiosis, but you're working at Briggs and Stratton, you're going to have a hard time connecting that to it, and it may not be considered work-related in that regard. Now, COVID is, as an occupational disease, you kind of look at it from the disease standpoint as, okay, if you're in the healthcare field or if you're in some kind of field where you're exposed to it much more, because of your occupation, you're exposed to it much more frequently or having to deal with it all the time, then it's going to probably be considered an occupational disease for like a healthcare worker. If it is not in the healthcare field, then it may be an occupational injury, and what you have to establish there is that there's a heightened level for communicable disease, that not only did they contract it as a result of their work, but their work placed them at an increased risk of contracting it over what the general public has. Because if it's communicable disease, well, they could have called it at the supermarket, they could have called it at work, from that standpoint. So it's treated differently from that standpoint there. In fact, I'd mentioned in a previous episode, a podcast episode, that I was working on a Supreme Court brief, and that's actually in a COVID case is the Supreme Court brief I'm working on. And hopefully the courts are going to rule in my favor in this one. Right now, there's only been one Kentucky Supreme Court opinion on COVID, and it was under the occupational disease standard. Mine is an occupational injury case, and so it's going to be interesting to see how that is. So far, I was successful in front of the administrative law judge, and Court of Appeals board. The board sent it back. Court of Appeals reinstated the majority of it, and then they've taken it to Supreme Court. So we're going to, hopefully the Supreme Court will agree with what I think is the correct interpretation, and what the administrative law judge felt was a correct interpretation of the law and the facts in my case.
Outstanding. Best of luck with that. That sounds like you're breaking some new ground there, possibly.
Yes, we're breaking new ground because it's not been addressed by the Supreme Court yet. I don't know if there's another one there before mine or not. I'm not aware of another one at the Supreme Court level besides the one they decided a month or two ago on the occupational disease case. But so, yeah, this case is going to be interesting. I've been working on the brief for quite a while now, and I'll be glad when it goes out in the mail, to be honest with you. So,
it's like studying for finals, right?
Yes.
Got to get that last term paper in and get
Yes.
it done. No, I hear you. Well, okay, so we've talked about different things that may qualify you for workers' compensation, but now let's talk about some of the various types of benefits that you could get. And medical expense coverage is one of them, obviously.
correct, and that's a lot of times the first thing a potential new client asks me is, how are my medical bills going to be taken care of? And in Kentucky, medical is one of the items of recovery. In Kentucky, there are on the medical side, there's no copays, no deductibles. The injured worker should not be out any amount of money for medical treatment for a work-related injury, work-related hearing loss, work-related occupational disease, or cumulative trauma. Doesn't matter what type it is. The damages we're going to talk about that you can recover kind of apply to every one of those pretty well equally, except on the hearing loss you have to have the 8%.
Right.
So medical is there in Kentucky. One good thing about Kentucky law as well is not only are there no copays and deductibles, but the medical continues for a period of time. It continues for as long as you don't settle your future medical benefits. It would continue for 15 years, or you don't let the statute of limitations expire. It will continue for 15 years for reasonable and necessary medical associated with the work-related injury. So if it's experimental treatment, workers' comp probably is not going to have to pay for it. If it's not for the work injury, they clearly do not have to pay for it in that situation. So it has to be reasonable, necessary, and for the work injury. And if it is, then the medical treatment should be covered for 15 years. And at the end of that 15 years, you have the option of asking a judge to continue the medical for the rest of your life. Now, there are certain injuries that medical goes for a lifetime. If you're permanently totally disabled, if the injury results in you having a prosthetic, things like that, then medical is automatically lifetime in those situations, and you don't have to ask for it because they know someone with prosthetics are going to have treatment for the rest of their life and replacement prosthetics, etc. So that's kind of a given in those situations under the law from there. So that is the one of the best benefits that I can obtain for someone to make sure they get that medical treatment for 15 years or lifetime. In Kentucky is one thing a lot of people don't know, and most insurance companies don't tell people, is that your mileage that you travel to seek medical treatment. I work in practice in Western Kentucky, is where my offices are. I practice all over the state, but I practice in a rural area, and a lot of times people in Murray, for instance, if you have a spine injury and need to see a spinal doctor, there's not one in Murray. You have to travel to Paducah or somewhere else to see a spinal doctor. And a lot of my clients go to Nashville for treatment and incur a significant amount of mileage and gas and wear and tear on the vehicle seeking medical treatment. Under Kentucky law, you're entitled to reimburse that mileage, get mileage reimbursement for the time you spend, not the time, but the miles you spend going back and forth to see a doctor for treatment of the work injury.
And if I recall from the episode we did on this, there's a 60-day window. So once you've incurred the mileage, you've only got 60 days to submit the form, correct?
Correct. You got 60 days to submit the form, and the form is a Form 114, and we talked about that in that episode.
When we did designated physicians, we actually kind of did two topics in that one episode, but I'll put a link in there. If you look for the episode that's going to say designated physicians form, the second half of that actually deals with mileage reimbursement. Right. And I think we actually included a link to that form, actually.
Yeah, I think we did to the designated physician and the mileage reimbursement form. Designated physicians, Form 113, mileage reimbursements, Form 114.
Well, and the other nice thing about the medical benefits with workers' comp is they start pretty much immediately. You don't have to, it's not like a car wreck where you're proving fault and you're trying to figure out down the road, eventually this case will settle and then I'll start getting some money. This happens pretty quickly.
As a general rule, it does happen pretty quickly. The insurance company is entitled to investigate the accident. So it kind of depends to some extent, but most of the time the decision is made fairly quickly, usually 3 to 4 weeks tops as a general rule on making the investigation and starting to pay the medical bills. Some they may take a little bit longer than that, but usually the medical kicks in pretty quickly. Now, if you go to the emergency room, you may get that bill in the mail, or see that they billed your health insurance because they didn't know who to bill from a workers' comp perspective. That can usually be resolved fairly quickly and straightened out fairly quickly. But if you get the bill in the mail, then you just send that into the workers' comp or contact them. But it's normally it's just because they didn't know who to bill, so they send it to the injured worker, and then that process. Once you get the workers' comp information and the claim number and all to give to the medical providers, that resolves then, and you get the other bills that you've gotten to the insurance carrier, and hopefully they pay them without any problem. So.
And there could be a copay or something like that early on, but you're going to get reimbursed for that once that claim is set up. Sometimes you're going before that claim actually hits the system.
What I see frequently, you go to the hospital, you can get in and out without to the emergency room, get in and out without having to pay them right then and there. But then they give you a prescription. You go to the pharmacy, and the pharmacy's not giving you that medication until you pay that copay on your health insurance. And you can get that back at a later time. That you, again, use the Form 114 to do that, submit that in.
Okay. So, Jeff, we talked about medical expenses. Let's now talk about temporary total disability, TTD benefits.
Yes, temporary total disability benefits are what you receive when you're off work under doctor's orders for a work-related injury. In Kentucky, temporary total disability benefits are paid out at 66 2/3% of the state average weekly wage. There is a cap on that for temporary total disability that varies from year to year on what that state is. But you get 66 2/3% of the state average weekly wage. Cap for 2025 was $1,231.22. It's going to be up a little higher than that in 2026. I think they've set that number now, but I'm not sure that I've seen it just yet for 2026. So unfortunately, if you make more than that, substantially more than that, then that will kick into play. And unfortunately, you may not get that. So some very high wage earners lose more than 1/3 of their pay. Workers' comp benefits are not taxable, so that's the reason there's that 1/3 reduction from and you only get 66 2/3% because they don't take taxes out of it, and at least the legislature thought that was close to what most people after tax bring home pay is somewhere in that neighborhood. And now that the Kentucky law is, in my opinion, weird in this regard, but the way the statute is written is you've got to be off work 7 days to get paid temporary total disability benefits, and you have to be off work 15 days to get paid for the first 7. So if you're off work 10 days, you get paid for day 8, 9, and 10. If you're off 15 or more, you get paid for every day that you're off work in that regard. And that is, so that's kind of how the temporary total disability benefits works. Now, there is a little bit of a quirk to that, and that is if you have a second job. A lot of people do work 2 jobs. If you have a second job and your employer knows that you're injured knows about that second job, then your wages from that second job are used to calculate your average weekly wage to determine what your temporary total disability rate is.
So they're added together.
They're added together. So if you have a job where you're earning $600 a week and then you have a second job, you're earning $400 a week. If you're injured on the $400 a week job, your temporary total disability benefits is going to be based on, if both employers know about it, is going to be placed on you're earning $1,000 a week because that's what your gross was a week from that standpoint. So your temporary total is going to be 66 2/3% of $1,000 a week instead of $400 a week there. And another side to this is, temporary total disability is paid out until you reach maximum medical improvement or you reach a level of improvement allow you to return to work. So if you reach maximum medical improvement and you're still not able to return back to your employer, workers' comp is going to stop at that point in time because it's no longer considered temporary because now it's considered a permanent injury. And you may, if you're able to go back to some work, then you can look for other work at that point in time and try to get some wages coming in, but no, the workers' comp check is going to stop. The other side is if you reach a level of improvement that allows you to go back to work, then workers' comp stops at that time, most of the time. So if you're released to light duty and you can go back and work full-time light duty, and get your regular pay, workers' comp kicks out at that point and you don't receive workers' comp. You can't receive your full pay and workers' comp as a general rule. But if you're released light duty and the employer says, well, we only have 20 hours of light duty per week, not 40 hours of light duty per week, so you're only getting half of your pay, then Kentucky now has what I refer to as temporary partial disability. And that is that, if normally your bring home pay was $800 a week, so your workers' comp check, $900 a week, so your workers' comp check is $600 a week, and now you're making $400 a week, well, then workers' comp has to, after taxes, $400 after taxes, because it looks at the after-tax wages, then workers' comp has to make that other $200 to bring you up to getting $600 a week, the temporary total disability rate. So they make sure you get that. Once you go over the temporary total disability and after-tax money, then the workers' comp check would not pay for those weeks.
And friends, if you're listening to this, and again, I've used this example before, it sounds like we're doing math on the radio, and sometimes it gets a little confusing. It's a good time to call Jeff and just say, okay, Jeff, here's my situation. What do you think? I mean, Jeff, you've offered free consultations since you opened the practice.
Yes, I do offer free consultations. If you've had a work injury and you have questions about whether you're getting paid correctly or what you're entitled to, in that regard, you can call my office and we'll get some information, see about setting you up an appointment, and be happy to discuss that situation with you.
So, Jeff, we've talked about somebody who's been injured and they've been off work. Now, maybe they either can't return to work or maybe they can get partial disability, temporary partial disability. Let's transition into permanent partial disability.
Permanent partial disability is the situation where a person has suffered an injury, they've reached maximum medical improvement, and they have some disability or some impairment as a result of that injury. Under Kentucky law, for permanent partial disability or permanent total disability, you have to have an impairment rating under the 5th edition of the AMA Guides to Impairment, which is a book nobody's ever heard of unless they've been involved in workers' comp before, because that's about the only time that book is ever used. But if you have that impairment rating, then you're entitled to permanent disability benefits under Kentucky law, permanent partial disability. Even if you're back at work doing the same job, earning the same wages, you're entitled to something. If you're obviously depending, your benefits are going to vary depending on a variety of factors on what you're going to be eligible for under permanent partial disability. So, they're going to look at what your impairment rating is under the guides. The higher the rating, the more money you're going to be entitled to. There's a factor contained in the Workers' Compensation Act that kind of corresponds with the impairment rating that comes into play. Do you have the physical ability to go back and do the job that you were doing at the time of the injury? If you are, then that's valued one thing. If you're not, then there's an increase in value for that. Are you earning greater wages, same wages, less wages? That makes a difference on how much you're entitled to. What's your age? Because obviously age factors into how disabled someone is. A 55-year-old that suffers an injury is going to be affected differently than a 25-year-old that suffers the same injury. And so your age comes into play, your education, and your past work history to some extent all comes into play in determining what you're entitled to in permanent partial disability benefits. So there's a lot of moving parts that have to be calculated and taken into account in determining that in that regard. And frankly, a lot of times there can be a dispute where a lot of the disputes arise is what is the correct impairment rating, because the insurance company doctor may think it's one thing and the treating doctor or another doctor may think it's substantially greater.
So in some common examples might be, in one of the recent episodes we talked about auto parts plants and metal forming facilities where you've got a lot of stuff in the air and a lot of punch presses, and you actually used to operate a punch press for Briggs and Stratton years ago. Maybe you've lost a finger. Okay, you're going to have a disability of some sort. Okay, correct. For that, so you can still go back to work, but here's an example of you have a partial permanent disability. So that's an example.
Yeah.
Maybe you got a metal shard in your eye. Maybe you actually lost the eye, but you can still return to work, but you have this disability because you're blind in one eye. So these are examples of this permanent partial disability, right?
Absolutely. That's it. Or, if you have a back injury and have back surgery, but you have a good recovery and you get back to work, that's permanent partial disability. You've had a permanent injury. Once your back's operated on, your anatomy is altered forever at that point in time, and so you've had a permanent injury. And a lot of people want to, I've had clients come in and say, well, I don't think this is, even though I may be entitled to something, I'm back at work. I'm earning the same wages. I don't know that I really want to pursue the claim, and that's fine. It's everybody's own decision. But one of the ways you lock in that medical, the 15 years of medical, is by settling that permanent partial disability. And then in that settlement agreement, it says, and the employer is liable for medical under the Workers' Compensation Act. And so you lock in that future medical for that 15-year period of time for that permanent partial disability or permanent injury that you've suffered in that regard. If you don't settle the claim, then the statute of limitations could run, and when the statute of limitations runs, you don't get medical anymore. And the statute of limitations, for those who don't understand what that is, there is a set deadline for filing a claim. And once that deadline is passed, then you don't get to pursue that claim anymore, or you may not be able to pursue that claim anymore, I should say. But most likely you're not going to be able to. So for a work injury, it's 2 years from the date of injury or the last payment of temporary total disability benefits. There's other things that can toll the statute of limitations. Occupational disease is 3 years as a general rule, but there's things that can toll that as well. So you've got there's a time frame for pursuing these, and when you settle the claim or file the claim, then you kind of help lock in that future medical for you.
Yeah, that makes a lot of sense. So now we're going to transition, I guess, into what I'll call worst case scenario: permanent total disability.
Permanent total disability. I didn't say, well, go on permanent partial disability. You get whatever your rate is, you'd get that rate for 425 weeks or 520 weeks, depending on the severity of the impairment rating. Permanent total disability is going to continue to age 70 or 4 years. If
I'm 68, I'm hurt on the job.
You get 4 years, but the minimum payment, if you're 68 and have a permanent partial disability, you get 4 years. At that point, benefits stop at 70 or 4 years, whichever is the greater of the two for permanent total disability. In that regard, so but most of the time, age 70 is what it is. Occasionally, you have people work later than that. In permanent total disability, you have to have an impairment rating, but then a lot of these other things that don't really come into play, because if you're totally disabled, then you get your total disability rate. Your temporary total and your permanent total disability rate's the same. So it's 66 2/3% of your average weekly wage paid out till age 70 or 4 years, again, whichever is the lesser of the two. So
Okay. And then an interesting.
greater of the two.
Okay, and then so an interesting benefit that we haven't talked about yet is actually vocational rehab.
Correct. A lot of people don't realize that they're entitled to that, and frankly, unfortunately, some attorneys don't pursue that on behalf of their clients like they ought to, in my opinion. But if you suffer an injury and you're not totally disabled by the injury, or even if you are totally disabled by the injury, we can look at getting you retrained into another field if you cannot go back to doing the job you were doing. Now, if you can physically go back to the job you were doing, or jobs you've done in the fairly recent past, we're not going to be able to get you vocational rehabilitation. But if you've been a factory worker doing heavy lifting in your job for the vast majority of your career, and you suffer an injury where you can no longer do that, then we can look at getting you sent to school to rehab, either school or trade school, whatever it may be, to learn another field so that you can get back and earn a good wage again. So we can look at getting you retrained. You can get usually a year without any problem, up to 2 years of vocational rehabilitation to get you back into the work market, into a good paying job in that regard.
Outstanding. And I think in the past we've had an episode on this. You mentioned that age obviously is a factor in this decision, right?
It is. I mean, a judge, if somebody's 65 years old, a judge is not going to make them send him back to that person back to school. In all likelihood, there, even if it can't, and they plan on working until 80, the judge is going to say, no, I'm not going to make them pay for you to go to college or go to this trade school at 65 years of age when you're hitting your regular retirement age in 2 years.
What if I'm 28, 32, 36, something like that? I've still got work
Even
life.
50.
Yeah.
Even 50. I mean, if you, there gets to be a point, and it's going to vary from person to person and what the restrictions are in that regard. If I've got somebody that, is 50 years old, but their injuries are so severe they're on Social Security disability, and we're looking at permanent total disability here, the judge may say, I'm not going to do that. If they want to get retrained, fine. I'm not going to make them pay for it. From that, they may make them. It's going to, but it varies case to case. Younger individuals, no doubt that you can, if they cannot go back, you should be able to get to voc rehab. And I've been able to do that for several clients in my career.
Outstanding. So, Jeff, The thing about workers' compensation is you're actually able to handle cases all across the Commonwealth. So really anywhere in Kentucky, I mean, you're able to take that on. You've got the primary office, and we usually record these episodes here in Murray, but you've also got the secondary office up in Hopkinsville, right?
Yes, I've got an office in Murray and an office in Hopkinsville, but you're correct. I do represent clients all over the state. I have a lot of clients up in the Bowling Green area, in the Louisville area right now, in Lexington. And, most of what we do, I can do over the phone or by video conference and by email. But I travel to those locations frequently as well, and I set up meetings with clients there at different locations from that standpoint. So if you've been injured anywhere in Kentucky, I've handled, as I've said before, I've handled cases from Paducah to Pikeville, and I've handled them from Murray all the way up to northern Kentucky. So if you're in Kentucky, I can handle your workers' compensation claim. If you want me to handle your workers' compensation claim, you can reach my office by calling 270-753-0053. I do have an 800 number, reach the same phone. It's 1-800-844-5108. And so you can reach out to me, and we'll be happy to get some information, see if it's a case that I can look at and take on for you from that standpoint. And I've done this for several years now, working on my 34th year of handling workers' compensation cases in Kentucky. And if you listen to these podcasts, you know that my office has a motto that I strive to live by, and everybody in my office strives to live by, and that is that we try to provide small town service and deliver big city results. And if you are here in Murray, we're going to try to do that. If you're in Pikeville and you're my client, I'm still going to try to provide you small town service and deliver big city results for you from that standpoint. We strive to do that in every case we handle.
That's outstanding. And Jeff, as we conclude this episode, obviously you're working on yet another brief for the Kentucky Supreme Court. You've been up there many times. We've got a number of episodes in the podcast about, your track record up there before the Supreme Court. You've got so many positive Google reviews, and this is just a testament to the type of work you're doing. I know a lot of people think, well, no, I need to get this guy over here closer to me. Well, yeah, I mean, you've got that option, but you've got, like you said, you're working on your 34th year, and you tend to know this. You get a lot of referrals from your colleagues across the state. They bring you in to handle workers' comp from all over the place, and I think that equates to just a level of respect they have for your knowledge, your background in this, and your abilities. So, congratulations to that.
Thank you. Yeah, that is. I've seen people say this, and it is, I think, very correct. One of the greatest compliments another attorney can give me is a referral. That is, it's fine to tell me I did a great job on this or do that. When you refer a family member, friend, or a client that you're handling one thing for, but you need me or another attorney to handle something that you don't handle, like workers' compensation, that referral, that is, to me, that's one of the biggest compliments that can be provided to me.
Well, they're actively earned, man. They're never given. They're actively earned. So congratulations with that.
Thank you.
Friends, we hope you've enjoyed this episode, and we'll be back in another 2 weeks or so with another good episode. So thanks for listening. Jeff, thanks for your time.
Thank you.
Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook at the Roberts